Legal cases, legal issues, legal matters. You're watching WFTV's Law Talk with anchor Christopher Heath and expert legal analyst, attorney Mark NeJame.
All right, let's talk about some of the current cases, issues, and legal matters that our viewers are talking about. Joining me today is legal analyst, attorney Mark NeJame of the NeJame Law Firm.
Hey, Chris.
One of the things we're watching is what Congress is up to, and it's this idea of protecting not only same-sex marriage, but also interracial marriage. The kind of springboard for all this, the genesis, if you will, was when we had the decision come down on abortion. And all of a sudden you hear the justices raising the prospect of right to privacy. Well, if it doesn't cover abortion, does it cover same-sex marriage? Does it cover interracial marriage? Congress is stepping in and saying, let's codify this in law.
Yeah, I think that we see that the pendulum can always swing wide in politics. And it's kind of like, be careful what you pray for, you might just get it. And in this circumstance, we now have issues that are really coming to the forefront, and it's concerning to so many Americans. Same-sex marriage, we've seen a true sexual revolution occur over the last many years, handful of years, 10, 12, 15 years, where we were talking about it being illegal to be same-sex marriage, to living together and having a contract. And now pretty much accepted by the majority of Americans, if you believe the polls, that they believe in people's rights to choose. The interesting thing is that this juxtaposes against those who go, it's wrong, but then on the other hand, they go, it's a state right and right of privacy and everything else. So it becomes very complex. I've never understood it. I have to share with you, we do our best to keep out of political, but if we have a 14th Amendment, if we have all people are created equal, then why do we have a restriction on what people can do in their own private lives? And I think that really comes to the crux of it. Can a state, where they're having state rights, restrict people still from choosing?
Let's get into what this law will do, because essentially the law right now does nothing. The law simply says if Obergefell, which legalized same-sex marriage, falls, if Loving v. Virginia, which legalized interracial marriage, if it falls, then all of a sudden we've established a new floor. And that floor basically is this. If you are married in a state and it's legal when you got married in that state and you move to another, that other state has to recognize that legal marriage, even if it's illegal for you if you got married in that state. If you were legally married in another state, it has to be recognized.
Full faith and credit. We see that oftentimes where one state will recognize the rights that you have elsewhere. But it really starts becoming a very, very frightening area, because when we're starting to have picking and choosing of when you want to support an individual's rights, and then you start bringing in your own religious morality beliefs, it becomes really very hypocritical, and we're seeing it. You can't pick and choose and say, we can legislate this to restrict your rights, but on the other hand, we want freedom to be able to, we want to stay out of that. You know, does the government have the right to intrude in your bedroom? Does the government have, even if it's a state rights thing, do they still have that right? And it becomes quite complex. And I think that, as we said before we went on, you know, we can't imagine even the most conservative states saying, no, they're going to ban interracial marriages. But has this opened the door? Is this allowing that? And I hope that, of course not. But there's a strong contingent that are saying it's a state right. And so when you start having states that might have certain restrictions, and then you complicate it, because in Florida we could do something, but then we move elsewhere and you can't, what ends up happening? Where's the enforcement? It just seems like there needs to be some consistency, and we need to allow that 14th Amendment, we need to allow people to exercise their own personal choices, as long as it doesn't infringe on the right of another.
And you mentioned earlier, I mean, it does feel a bit like a pendulum, where at times you will see the Supreme Court and the federal courts really trying to make all 50 states kind of be in lockstep with one another, and then it swings the other way and it says, you know what, 10th Amendment, if you want to do this, Oklahoma, great. Arkansas, you want to do something different, go for it. There does seem to be a little of a push-pull here. This law very much says, no matter what the courts ultimately do, we've established a floor. We've established kind of a baseline.
And you're right. And there's also another aspect to this. And although the U.S. Supreme Court's not supposed to be political, when you look at the polls, they are in their lowest standing ever. And you have Justice Roberts, the Chief Judge, who we know is very sensitive to that, leans to the right, but is really attempting to be a peacekeeper. I think that the credibility of the U.S. Supreme Court is clearly entering into this right now. I think they are sensitive as to what they're creating for the future. And although we know it's a very conservative court right now, if that pendulum swings too wide and the public loses faith in that court, it becomes problematic for our democracy. The only reason courts work is because we allow them to work, because we say that we accept what a court's ruling is going to be. If we get to the place of not accepting the authority of a court and respecting it, then we have challenges. And I think that when you start looking at what the Supreme Court is doing and the way it's ruling and the public perception of them, I think Justice Roberts will in fact move some of the stronger beliefs of some of the, I'll say, ultra-conservatives that have recently been appointed to the bench to try to find a way to moderate it so that there is an accommodation.
And it comes down to people want some certainty. They want to understand, if this is what I've been used to for a long period of time, do I have a level of certainty there? Is it going to be all thrown upside down? And that's where it's important.
And we saw it with the abortion ruling, of course. You know, the 50 years we had Roe versus Wade, and that got reversed. So if it can be reversed there, you know, the question then becomes legitimately, why can't it be reversed on other areas that we've taken for granted? And so therein lies the crux of the problem.
And of course, Congress can always act as they're choosing to do this time and say, you know what, we don't need it to be in the courts. We can actually codify this into law.
That's right.
Of course, they have to act. So anyway.
And it has to be constitutional.
There you go. All right, Mark, I appreciate it. Thank you as always. If you'd like to see more of this Law Talk or any of our others, visit our website, WFTV.com/legal, or join us each week right here on Facebook. I'm Christopher Heath, and thanks for watching.
WFTV's Law Talk was brought courtesy of the Personal Injury and Accident Division of NeJame Law.